Hello everyone. Welcome back to our channel, UKVI Global. We hope you're doing great. In this video, we're going to talk about changes to UK visa and settlement rules after the 2025 Immigration White Paper. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. On May 12, 2025, the UK government released a sweeping policy white paper titled Restoring Control over the Immigration System. This blueprint laid out a series of reforms designed to tighten migration routes, reshape settlement pathways, and reduce overall net migration. While the document itself does not change the law, it outlines firm intentions that guide future amendments to immigration rules. Some proposals have already materialized, yet many await implementation through consultations and formal rule changes. Key proposals in the May 2025 White Paper. The White Paper spans broad reforms and targeted interventions. 8 headline proposals were detailed with preliminary estimates of their potential impact on migration levels. These include 1. Narrowing the skilled worker visa job list. The government proposed sharply reducing the number of occupations eligible for sponsorship. Medium-skilled roles, RQF Level 3 to 5, would only be sponsorable if the Migration Advisory Committee identifies a compelling labor need and confirms domestic hiring efforts. 2. Ending the social care worker exemption. Employers would no longer be allowed to recruit social care workers from overseas, a substantial change for a sector that has relied heavily on international labor. 3. Introducing a levy on international student fees. Ministers are exploring a financial levy on the overseas tuition income of English universities, requiring legislation to enact. 4. Tightening university sponsorship requirements. Stricter compliance thresholds would make it harder for institutions to maintain their license to sponsor international students. 5. Shortening the graduate visa duration. The standard graduate route would shrink from 2 years to 18 months. 6. Strengthening English language standards. Higher testing thresholds and requiring dependents of work visa holders to demonstrate basic English proficiency. 7. Extending the path to settlement. The baseline qualifying period for indefinite leave to remain would rise from 5 to 10 years, with adjusted timelines based on occupation, income, and individual circumstances. 8. Expanding high-skilled visa opportunities. Easier access to the global talent, high potential, and similar routes aimed at innovation-driven migration. Broader areas covered in the white paper. Beyond quantifiable proposals, the document also addressed reforms to dependent and family visas, Article 8 ECHR considerations, foreign national offender deportation, and the creation of a labor market evidence group. Implementation timeline and current changes. There is no unified timetable. However, some reforms have already taken effect. July 22, 2025, reduction of skilled worker eligible occupations. July 22, 2025, ban on overseas recruitment in the social care sector. November 2025, liberalization of global talent and high potential routes. Impact on graduate visa holders. Although graduate visas do not require sponsorship, many holders plan to transition into a skilled worker visa. Those in medium-skilled occupations removed from the eligibility list in July 2025, including roles in transport, dentistry, and prison services, lost that pathway. Will settlement now require 10 years? On November 20, 2025, the government clarified that the baseline qualifying period for ILR would be 10 years. Yet a tiered structure is proposed. 5 years, high-skilled workers earning £50,270 plus, healthcare and education professionals. 5 to 7 years, those with significant community volunteering. Up to 15 years, people working in medium-skilled roles. 20 years, refugees, except via resettlement schemes. Up to 30 years, individuals who previously overstayed or entered illegally. Earnings of at least £12,570 for several years will be a mandatory threshold. The consultation runs until February 12, 2026. Who is affected? People under the EU settlement scheme are entirely excluded. Partners of British citizens and Hong Kong BNO holders would retain the 5-year pathway but face new English and income tests. Skilled workers, dependents, refugees, and long residence applicants fall squarely within the reform scope. The Home Office intends for these new rules to apply to all individuals who have not yet secured ILR, beginning April 2026, though transitional arrangements may be considered. Other settlement reforms. The proposals also suggest that dependents must qualify independently for ILR and that ILR holders may continue with no recourse to public funds, restricting benefits solely to British citizens. Will MPs vote on these measures? Most changes will occur through statements of changes to the immigration rules, which take effect automatically. Parliament does not hold a binding vote unless MPs successfully pass a rare motion of disapproval. However, changes involving a student fee levy or naturalization law will require full legislation and parliamentary approval. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.